Chapter 5 in the 11th edition book. This would be part 9. We're still talking about the trial process. And we've come to this slide on the types of evidence. And first let me point out that there is a difference between evidence and facts. Okay, facts are very broad. But in our legal system, for one reason or another, the system has decided that not all facts can be presented in a trial. So what can be presented in a trial we call evidence. And we have a very strict rules or code of evidence that says what can be presented and what can't be presented. And of course the judge is the final say-so on that. So remember that everything that's a fact is not necessarily admissible as evidence in court. So what are the types of evidence? We have testimony, documentary, real, demonstrative, judicial notice, and admissions. The main ones are the first four. So testimony is probably the one that presents the most amount of evidence in a trial. Testimony is where you have a witness that testifies, that states in court what they saw, what they heard, what they observed. It's their personal knowledge through their senses of what they saw. And they're limited to that if they are a layperson. Experts are given a little bit more leeway. Experts can offer opinions, and experts can actually give their opinion not based upon what they personally know, but what is in the record in the case. So an expert could read a medical record, have never seen the patient or the person, and offer an opinion, a diagnosis, for example, of that person in court. So that's testimony. Now, never think that testimony is not that important. Testimony is probably the most important thing. Okay, I often get asked by students when we're talking about a hypothetical situation, they'll say, well, how would you ever prove that in court? Well, you'd prove it by testimony. It may not be the best thing, but it may be all you have. Okay, then we have documentary evidence. Now, of course, again, document today is defined much differently than it was years ago. It's any kind of recording of information for the future. So it includes all kinds of modern electronic recordings, including taping, videoing, any kind of computer apparatus, the cloud. All those things are documentary evidence. Okay, real evidence is an actual thing. If you had a civil case where somebody in a bar picked up a baseball bat and clobbered somebody else over the head, and that person who got clobbered is suing that person for battery, the baseball bat would be real evidence. Okay, so it's something that you can touch that proves something in the case. Now, with documentary evidence and real evidence, you have to lay what's called a foundation. Okay, and a foundation means that you're showing the court that what you're presenting is authentic. It's real, and the foundation for various types of real evidence and documentary evidence can vary depending upon the particular document or the particular item of real evidence. So for example, if you're offering a photograph of something, you have to lay a foundation that shows that that photograph accurately represents whatever it's purporting to represent. So if you have a car accident, you're trying to show a picture of the position of the automobiles after the car accident, and you've got a photograph of it, you have to call a witness. That witness has to testify. You put the photograph in front of them and you say, do you know what this is? Yes, it's a photograph of the accident, and you have to show that it's authentic by having the witness say that it accurately represents the way the accident looked after it occurred. So you have to lay a foundation. Now, a couple things I missed with testimony. One of the things is that generally children can testify so long as they are old enough to understand the ramifications of telling the truth or what happens to you when you don't tell the truth. So ordinarily the judge will voir dire, as we say, question or have someone question the child to make that determination. There's no particular age limit with regard to that. Okay, demonstrative evidence is a little bit different. Demonstrative evidence is something that isn't actual but portrays something. So for example, if you brought a mannequin into court to demonstrate, for example, where the bullet entered the person by pointing to that area, that would be demonstrative evidence because the mannequin is not real. Okay. Now the rules on demonstrative evidence are that the judge has to make a decision whether or not to allow it, and the judge makes that decision by weighing the probative value, that is, whether it tends to prove the allegation being made by the person presenting it, and weighing that against any prejudice it might have against the other side. So if the value is much greater than the possible prejudice, the judge is likely to allow it. The other thing the judge has to consider is it helpful to the jury? If it's not helpful to the jury, then it doesn't matter anything else. So it has to be something that helps the jury understand the situation. So let me explain something here for you. Suppose that the inside of a house is something to do with the case, the evidence in the case. If you went through this house and you took a video of all the rooms in the house, that video would be real evidence. Okay, you'd have to lay a foundation, but it would be real evidence. On the other hand, if you had the owner of the house on the witness stand and you asked the owner to go up to a whiteboard and draw the various rooms in the house where they're located, that would be demonstrative evidence. It's not real because it's not to scale, it's not actual, but in a given situation it may help the jury understand, for example, where people were or where something was in relationship to something else. Okay, judicial notice is simple. It's where the judge is asked to take notice of a fact that's notorious in the area where you're at. So you could ask the judge to take notice that the courthouse is located on Main Street on the courthouse square. And if the judge says that everybody knows that, then the judge will take judicial notice of it and the jury will be so instructed. Admissions are simply where one of the party has admitted something, oftentimes through discovery admissions, and then you don't have to prove it at trial. Okay, we're going to stop there with Part 9 and we'll pick up with Part 10.